When is copyright deemed to be infringed? Copyright infringement is unauthorized use of someone's copyrighted work without permission, thereby infringing certain rights of copyright holder, that is right to reproduce, distribute, display or perform the protected work. Section 51 specifies when a copyright is infringed. Direct copying, reproducing a part or portion of work. Indirect copying, converting owner's work in other form. Substantial copying, copying major portion of the work. A person imports infringing copies of a work. A person without obtaining the permission of the copyright holder does any act which only the copyright holder is authorized to do so. Test of infringement, quantum of the work copied, purpose of copying the work, the likelihood of competition between the two works. What does not amount to the infringement of copyright? The Copyright Act provides for certain exceptions, defenses which can be used for action against infringement. Section 52 is an exhaustive section which lists the acts which do not constitute infringement. Parody and pastiche. Parody means to use the existing work of someone to create humor or use it for mockery. New reporting. A news reporter may sometimes use the copyrighted material to report the current event. Libraries. The libraries often lend readers a book for a certain period and makes copies for its user. Education. Another exception to copyright infringement is the use of copyrighted material for educational purpose. Research and private studies. Researchers have to use various copyrighted sources for the research purpose. Private copying. Private copying refers to the copying of material from one device to another without infringing the right of the copyright holder. What are the remedies against infringement of copyright? The copyright holder can take criminal proceedings against the infringer. The criminal remedy is not an alternative to the civil remedy but is complementary to it. Civil remedy is covered in under section 55, injunction, restraining a person by the way of injunction from doing the act of infringement. Damages, claim in the form of monetary amount, account of profit, in the profits which the infringer defendant may have made by wrong use of copyright. Damages for conversion, when the infringer defendant converts the copyrighted work into another form without the consent of the owner of copyright. Criminal remedy, section 63, imprisonment of infringer or imposition of fine or both. Remedy for seizure of the infringing copies from the infringer of copyright. Administrative remedy available under Copyright Act with authorities that is the Registrar of Copyright, the Copyright Board, and the Copyright Societies. Notes on copyright societies. Copyright societies is a legal body which protects or safeguards the interest of owners of the work in which copyright subsists. Section 33 to Section 36A regulates activities of copyright societies. The copyright societies gives assurance to the creative authors in the commercial management of their works. It is a registered collective administration society. Such a society is formed by copyright owners. The functions of copyright societies are as follows. It grants licenses of the copyright in the work for reproduction, performance or communication to public. It locates the infringement of the copyright and initiates legal proceedings. Let's discuss few important terminology. Number one is reprography. Reprography means the making of copies of a work by photocopying or similar means. Government work. It means a work which is made or published by or under the direction or control of the government or any department of the government, any legislature in India, any court, tribunal or other judicial authority in India. Composer. Composer in relation to a musical work means the person who composes the music regardless of whether he records it is in any form of geographical notation, graphical notation. Author. Section 2, subsection 1 D defines author in relation to literary or dramatic work, the author of the work, musical work, the composer, artistic work other than a photograph, the artist, photograph, the person taking the photograph, cinematograph or sound record, the producer, in relation to any literary, dramatic, musical or artistic work which is computer generated, the person who causes the work to be created. Let's discuss the Patents Act 1970. Meaning of patents and terms of patents. A patent is an official document which gives exclusive right or a monopoly granted for an invention which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. Term of patents. Every patent granted is 20 years from date of filing of application. Requirement. Invention to qualify for patents. It should be novel. It must involve an inventive step. It should be capable of industrial application. Who is entitled to apply for a patent? Section 6, Application for patent can be made by person claiming to be true and first inventor, by any person being assignee of the person claiming to be true and first inventor, by legal representative of the deceased person. Procedure to register patent by owner. Filing of application in patent office. Priority document will be filed with application. Complete specification to be filed. Acceptance of specification. Publication of application. Request for examination. Examination and report of examiner. If approved, grant of patent. If any objection, division of application. Amendments after oppositions or objections, grant of patent. Categories of inventions that are not patentable. Section 3, sets of inventions which are not patentable. Invention which is frivolous or which claims anything contrary to established natural laws. Mere discovery of scientific principle or the formulation of any abstract theory. Mere arrangement or rearrangement or duplication of known device, each functioning independently or one another way is known way. A method of agriculture or horticulture. Topography of integrated circuits, a presentation of information, a mere scheme or rule of or method of performing mental action or playing game is not invention. Inventions relating to atomic energy. Let's understand compulsory licensing of patent terms and conditions. Compulsory licensing is when a government allows a third party to produce a patented product or process without consent of the patent owner or plans to use the patent protected invention itself. Ground for compulsory license. After 3 years of grant of patent, an application can be made to controller by interested person for grant of compulsory license on following grounds. The reasonable requirements of the public with respect to the patented invention have not been satisfied, or the patented invention is not available to the public at a reasonably affordable price, or the patented invention has not been operational in the territory of India. Terms and conditions for compulsory license. The controller, while settling the terms and conditions, should seek to secure the following: the royalty and remuneration for the patentee or other person who is entitled to benefit from the patent is reasonable. The person to whom the license is granted is to work the patented invention to the fullest extent and with a reasonable profit. The public has access to the patented articles at affordable prices. A non-exclusive license is granted. The right of the license is non-assignable. License granted for remaining term of patent. The license is granted with the purpose of supply in the Indian market. If required, the license may export the patented product. Revocation of patent. Section 63 deals with the revocation of patent. Revocation by surrender of patent by owner by giving notice to the controller. Revocation of patent in public interest by central government, medical emergency. Revocation for non-working as reasonable requirement of public are not met. Section 64. Patent can revoke on suit for infringement petition by any interested person. Section 65. Revoking of patent on um, Section 65. Revoking of patent or amendment of complete specification on direction from government in case of atomic energy. Section 66. Section Section 66. Patent can be revoked on ground of mischief to the state or generally prejudicial to the public. Can be revoked by the central government. Discuss various rights available to the patentee. Right to exploit the patent, right to grant license, right to surrender the patent, right to sue for infringement of patent, right to use and enjoy patent, duty to disclose, duty to request for examination, duty to respond to objections. Responsibility to ensure patent not being infringed. The onus or responsibility of proving an act of infringement is on the plaintiff. There is no infringement on invalid patent. In infringement, it is immaterial whether the act was done with or without intention. If defendant not aware of patent, he will not be held responsible. Remedy is injunction. Patent of addition. Section 64. Patent of addition. Section 54. When an application is made for a patent in respect of any improvement or modification of an invention described in complete specification in the main invention, and the applicant also applies or has applied for a patent for that invention or is the patentee in respect thereof, the controller may, if the applicant so requests, grant the patent for the improvement or modification as a patent of addition. A patent shall not be granted as a patent of addition unless the date of filing of the application was the same as or later than the date of filing of the application in respect of the main invention. The Berne Convention. It deals with the protection of works and the rights of their authors. It is based on three basic principles. The three basic principles are: works originating in one of the contracting states must be given the same protection in each of the other contracting states as the latter grants to the work of its own national. Protection must not be conditional upon compliance with any formality. Protection is independent of the existence of protection in the country of origin of the work. If, however, a contracting